morning, ladies and gentlemen, and welcome to this webinar. My name is Leena Leikas, and I'm opening this as a chairperson of the ENNHRI Legal Working Group. And in my national role, I am an expert in the Finnish Human Rights Center, which is an NHRI with A status in Finland. This series of webinars consists of 4 such events, as you all know probably. The first 2 are open for wider audience, like this one and the next one. And the last 2 are for the more specific selected audience. And as I noticed that we have a lot of persons in attendance today, it makes me very happy because interest in the implementation question is very important. So before we start the program, I would like to thank ENNHRI Secretariat for organizing these webinars together with the European Implementation Network and the Department for the Execution of Judgments at the Council of Europe. This type of cooperation is very, very useful on so many levels, and we are very grateful that ENNHRI and all the other organizers have put the effort in to organize these webinars. And I also like to thank Katrine from the ENNHRI Secretariat for her invaluable support for the preparation of these events, and also for the legal working group at all the times, and to me personally as a chairman or chairperson of the working group. Being partial to the ENNHRI legal working group by my position, this kind of cooperation on the implementation enhances our capabilities in improving our own knowledge and helping us become more active in the implementation field. For those who don't know yet, the ENNHRI Legal Working Group is a hub for legal professionals from different institutions from all over Europe, and it brings together wide legal expertise for the exchange of information on important current issues, and also the European Court case law. In addition, it also builds up capabilities in many ways. Training is one of them. And since I'm talking about the working group, I like to invite new members from the institutions that are yet not represented in the working group to join us. You don't have to be a master of legal thinking or court case law to be a part. So don't be shy and get contact with Katrine at the Secretariat. So the legal working group has actively been promoting and in fact also submitting third-party interventions to the European Court. It has also prepared an upcoming guide for preparing such interventions, and therefore it is natural that we wish to continue further down the line and work on the implementation and see how we can improve the implementation and the human rights situation in member states. So taking small steps and hopefully improving the world. So today's webinar, you will learn about the non-implementation challenge and the need for greater involvement by the NHRIs, since the numbers are not very high on the involvement. And you will also learn about the execution process, the involvement of the NHRIs in the process at Strasbourg level, and you hear a best practice story from one of our colleagues on how to use the mandate to advocate for the implementation of the judgments on a national level. You have all watched the introductory videos, and if not, they are online and you can watch them afterwards. And I just want to point out that even without watching the videos, we all know that the insufficient implementation or the total lacking implementation of the judgment is a huge problem, and this is why we also have this seminar today. By the end of 2019, over 5,000 cases or judgments had not been fully implemented. And out of those, almost 4,000 were repetitive cases. So the same problems appear over and over again, which is also one of the reasons why NHRIs could look more closely into the implementation. So, as an advertisement for the new webpage at the Council of Europe since last year on the execution process, there is a link on the website, and if not, it will appear later. The execution department of the Council of Europe has put together a website for NHRIs and NGOs containing information and guidelines and examples of the work that can be done for the submissions and the themes that we also discuss here in the webinar. So the European Implementation Network that is co-organizing this event works with member states, partners, lawyers, civil society organizations, and communities from all over the Council of Europe region. And they are doing a good job helping others to participate in the implementation process. So without further discussion, I will give the floor or the screen or the microphone, however you say it here in these online forums, to George Stafford, who is the director of the Implementation Network. He has been there since 2018. Previously, he has worked at the Human Rights Court, the Council of Europe, and the Georgian Young Lawyers Association in Tbilisi. And he qualified as a barrister in London and has worked also as judicial advisor in Court of Appeal. So he has a lot of experience in the court-related matters. So, George, the floor is yours, and George will instruct you on other practicalities and introduce the other speakers and the program of the day. Thank you very much.
Hi, everyone. Thanks so much, Lena, for your introduction. As Lena said, my name is George Stafford. I'm the director of the European Implementation Network, known as EIN. And so we're a network of 37 different members composed of organizations from all over Europe. And we're the only organization in Europe focused entirely on the implementation of judgments of the European Court of Human Rights. So first of all, I just wanted to bring up today's agenda, just to give you all a good view of what we'll be doing, and so you all know what's coming up. So hopefully you should be able to see the agenda on the screen now. So first of all, you'll see that there's welcome and introductory remarks from Lena, which she's already gone through. Second, you'll see a point in the agenda on the non-implementation challenge. That's going to be a short intervention from me. I'm going to keep that as short as I possibly can because most of the points that I want to cover have already been addressed in the video presentation that has been circulated to all, and I hope that you all had a chance to take a look at. Then we'll have a short intervention also from Nikos Sideropoulos. Nikos is the head of division at the Department for the Execution of Judgments of the Council of Europe, and he'll be able to give you an expert view on implementation, the shared responsibility, and the operation of the implementation mechanism of the Council of Europe. Then we'll have a Q&A session. Hopefully that'll be as long as possible, so we can try and get as much exchange with all of you as possible. That's the most important part of these things, and no one wants to see a presentation which is just other people speaking. So we hope to hear from you. It'll be really interesting to hear your questions. Then we'll have a presentation from Dr. Simona Drenik-Bavdek, his assistant head of the Center for Human Rights at the Human Rights Ombudsman of the Republic of Slovenia. Now, Slovenia has a really strong record for implementing judgments of the European Court of Human Rights. And it would be very interesting to hear from Dr. Bavdek more about that, how that's happened, and how other countries can replicate that through the activity of national human rights institutions. Before I start with my comments, my brief recap presentation, a really quick housekeeping point. If you're not speaking, then it would be great if you could keep your microphone and your video turned off. That will help us transmit as well as we can over the internet connections. But if you do want to ask a question, please do go ahead and do so when we have the Q&A sessions. A couple of ways you can do that. You can sort of raise your hand in order to be brought in, and I'll transfer to you, and it'd be very interesting to hear from you. Or you can go ahead and write your question in the chat function, and I can pose it to our panel members and our speakers. So a very quick recap from me about the different aspects of the non-implementation challenge that we're facing in Europe. I really hope that you had a chance to take a look at the longer presentation video that we circulated on this subject before today's session, and the full information that I want to impart to you by way of introduction is in that presentation. So if you haven't had a chance to look at it, I really encourage you to take a look at it after today's session. But just by way of overview, from the perspective of the European Implementation Network, there's two significant challenges to the implementation of judgments of the European Court of Human Rights. One is the issue of inactivity on governments. So sometimes there's a risk that governments aren't active enough in engaging in pushing forward implementation. You'll see some statistics there. There's over 1,200 leading judgments pending in Europe today. 43% of the leading judgments from the last 10 years are still pending. Now, it doesn't mean to say that all of those judgments, there's nothing happening and no implementation is being pushed forward. But nevertheless, I think you'll agree that there's a significant issue there, and there needs to be more activity in this area. The other issue is the problem of ineffectiveness. Now, there's a risk if government activities for the implementation of judgments aren't monitored effectively by national human rights institutions or NGOs, then the activities, the reforms that governments carry out might not be as effective as they could be. And our research indicates that over 9 out of 10 leading cases don't have monitoring from NGOs or national human rights institutions. So there's a risk there that government reforms aren't effective if the people on the ground who know most about the human rights issues aren't monitoring them and making sure that the reforms really achieve things in practice. So what can NHRIs do to address implementation inactivity? There's two things. One is to promote structural mechanisms to improve ECtHR implementation, and you'll hear a lot more about that from one of our speakers today, Dr. Bavdek. And second, there's also the prospect of highlighting the overall implementation record of their government. That's a very interesting thing that NHRIs could consider doing. It's just presenting the relevant statistics to their government and saying that things need to improve. And that's something we can address a little bit more in the second webinar. So what can NHRIs do to address implementation ineffectiveness? I mentioned there's sometimes a problem that perhaps if governments are left to their own in regards to implementation, it might mean that they're not carrying out the reforms that are truly necessary. Two things to be done here. NHRIs can engage in dialogue with governments about ongoing reforms at the national level, just through straightforward advocacy. And second, make submissions to the Council of Europe Implementation Monitoring System. And that's a really important aspect of the monitoring process and ECtHR implementation that we'll be speaking a lot more about in later webinars. And I'm sure Nikos will have a lot to say about that in a few moments. So finally, an aspect of what I wanted to say is why are NHRIs important to ECtHR implementation? The three reasons: expertise, resources, and mandate. NHRIs have a lot of amazing knowledge and a lot of amazing personnel in the area of human rights. So they know the issues in the countries they're dealing with inside out. They also have significant resources. Obviously, all organizations, we never have enough resources to do what we want. But a lot of the work at the moment on the national level being done is by NGOs in terms of monitoring government activities. So NHRIs certainly have a significant amount of resources in comparison to them. And finally, the mandate. We hope that NHRIs are really well placed to address this non-implementation challenge. And we're really, really excited to do this training because we think that NHRIs are perfectly placed, let's say, in the national ecosystem to put forward the different arguments and put forward the different points on individual cases when it comes to implementation of ECtHR judgments. So without more from me, what I'd like to do now is hand over to Nikos Sideropoulos. Nikos has done a huge amount working with us and working with many NGOs and NHRIs to really open up the implementation monitoring process. And he's a really valuable person in that regard. No one knows more about the system than he does. So Nikos, I'll be handing over to you now.
Thank you very much, George. I hope you can hear me. Yes, okay, great. Thank you. It's a great pleasure to part in this first webinar on the implementation of the ECtHR judgments and the role of the national human rights institutions. For me, it's a pleasure for many reasons, because as I said, actually in my clip, in the doctoral clip, I had participated actually more than 12 years ago in a similar exercise the then Council of Europe Human Rights Commissioner, Mr. Hammerberg, on the implementation of the ECtHR judgments and the NHRIs actually role. That was in January 2008. It was a pilot program actually, which was piloted by 4 European national human rights institutions. It was Austria, Belgium, France, and Northern Ireland. Those were the pilot actually NHRIs who were piloting this particular project. We had an event in Strasbourg, which was very, very successful, but unfortunately, we didn't manage actually to keep the steam going. To see that this actually idea comes back and with much force and in a much more organized manner, for me, it's a great pleasure. When I talk about actually the ECtHR judgments and their execution, I usually start with a motto from a former judge of the European Court of Human Rights, François Tulkens, the Belgian judge, who said that a judgment of the European Court of Human Rights is not an end in itself, but a promise of future change. It is the starting point of a process which should enable actually rights and freedoms to be made effective on a national level. And I tend to reiterate actually this motto because there is much of substance, and it shows that a judgment in itself means nothing, be it a judgment by the European Court of Human Rights or a judgment by a national court. It means nothing if it's not properly, effectively, and promptly implemented by national authorities. The other major point that I would like to highlight from the start is that execution does not happen in Strasbourg. The judgments of the European Court of Human Rights are not executed by the Committee of Ministers, and this should be very, very clear to all of us. The execution happens in the countries concerned by the judgments of the European Court of Human Rights. It happens in the capitals. Authorities have to be well organized. They have to be well coordinated in order to adopt the appropriate measures to remedy the individual situation of the applicants and also to prevent recurrence of similar violations. Of course, the primary responsibility of implementation, as you know, under Article 46 of the European Convention, lies with the respondent state. The primary responsibility for the rapid, full, and effective implementation of the rights and freedoms enshrined in ECtHR lies with the contracting states. And as a consequence, every judgment obliges the respondent state to take immediately measures in order to remedy the situation, both at individual level but also at general level, in order to prevent recurrence of similar violations. The big step forward in the execution process and in our context actually happened in 2006. In 2006, CM rules changed, and actually by this change, actually there was an enhancement of the participatory character of the execution process. Under the new rule, which was adopted, Rule 9, which was adopted in 2006, the Committee of Ministers actually allowed non-governmental organizations and national human rights institutions for the first time actually to communicate formally with the Committee of Ministers and submit communications as the Rule 9 communications we all know today. But that was not for granted in the beginning. It took some years for the Committee of Ministers to open up. And in 2006, this happened. It was a very, very important year. This year saw that there was a slow but steady rise, actually, increase of communications, primarily from NGOs, and not so much by national human rights institutions, as Elena just said earlier. In 2017, in January 2017, 3 years ago, Rule 9 changed again, and the Committee of Ministers actually, for the first time, provided in their rules, in the CMDH rules, for the possibility of international organizations, human rights organizations, as well as for third-party interveners before the European Court of Human Rights to also submit formally communications to the Committee of Ministers in the execution process context. So I refer to all these developments because these are developments which show the participatory and synergetic character actually of the execution process. Execution process is not just a process or a dialogue or debate between the Committee of Ministers and the respondent state. It is a debate or dialogue which involves or should actually all major human rights stakeholders, and these are also NGOs, human rights NGOs. These are NHRIs. These are parliaments. And all institutions, all national institutions, which are directly or indirectly actually related to the execution of judgments of the European Court of Human Rights. It's directly or indirectly related to the human rights implementation process at the national level in general. Because this is actually what the execution of a judgment of the European Court means. It's the effective implementation of international human rights standards at the national level. When can actually a national human rights institution start submitting communications? Communications, as I said, is one of the major actually theme or area in where national human rights institutions and the EIN has focused until now. It is a very important part, but it's not the only one, the only thing that can be done actually by you. I will come to this a bit later, but I would like just to refer to the timing of communications that can be submitted to the Committee of Ministers, because I think there is a misunderstanding that an NGO or a national human rights institution cannot intervene or should not intervene in the early stages of the execution process. That means immediately after or shortly after the delivery of a judgment by the European Court of Human Rights. And this is a mistake, actually. It's a mistake for various reasons. One of the major reasons is that if the execution process does not start correctly and the major shortcomings at national practice or law are not identified from the start, then many problems will arise sooner or later in the execution process, and this has been shown in practice. That's why one of the major messages that I would like to transmit to you is that try to be active in the execution process from the start, just shortly after the delivery of the judgment by the European Court of Human Rights. So that you identify promptly and clearly the shortcomings which have to be remedied by the respondent state. And this includes the comments that can be made in this context by NHRIs or NGOs do not actually concern only the substance of the measures that have to be taken, but it may concern also the classification of the case. For example, if a case raises structural or complex issues, which should be actually under the so-called enhanced procedure of supervision by the Committee of Ministers, this would be also, or this can be clearly also identified and proposed by the NGO or national human rights institution to the Committee of Ministers. In this context, actually, I have a very good example of a communication we received actually last year, in March 2019, by the Dutch National Human Rights Institution, Human Rights Commission, I think it's called. That was about a case concerning detention conditions in one of the Caribbean islands, which belongs actually, is part of the Netherlands. The case is called Corallo against the Netherlands. The judgment of the European Court of Human Rights was delivered in October 2018. And approximately 3 months after the delivery of the judgment, and before actually the classification of the case by the Committee of Ministers to put it in enhanced or standard procedure, we received a very, very instructive and constructive letter, official communication from the Dutch National Human Rights Institution, identifying actually the structural problems which this particular judgment raised. And for us, that was a very, very constructive and very helpful, actually, communication, because it provided us with information we didn't know about this particular situation in the Caribbean island, which belongs to the Netherlands, is part of the Netherlands. And also it helped us make the decision to propose to the Committee of Ministers to put this particular case in the enhanced procedure, which happened. I just refer to this example showing the communication at the early stages, actually, of the execution process can help a lot. Can help a lot, not only identifying the real dimensions of the problem or the situation which has to be handled, but also showing the road to a more enhanced, more systematic, actually, examination of a case or of an issue. Institutions and NGOs at the same time. The second point I would like to raise the issue of teams on which nationalists or NGOs can be in teams of education. Encourage very much actually active in following up and providing information, feedback with me. In one of the measures which have been will be that you look into these major issues at the national level, see the relevant judgments delivered by the European Court of Human Rights, and examine or consider being more engaged actually in the execution process, which can happen not only in Strasbourg before the Committee of Ministers, but primarily in your capitals. Try to engage with decision makers, try to consult with them, engage with us at the same time if you need more support or assistance. We're here to help you. As we're here to help the national institutions themselves actually to deal with the issues or questions which are raised by the European Court of Human Rights judgments. I think I've run out of time. That's all I want to say for the moment, and I would be happy to reply to any questions you may have. Thank you very much.
Great, thank you so much, Nikos. That's hugely appreciated. It's now time for us to have some questions. We'd really like to hear from you and get your engagement. So please don't hesitate to sort of raise your hand or put a question in the chat. You can even just sort of start speaking if you like, if you turn off your microphone and turn on your video. It would be a real pleasure to hear from you. Maybe while we wait for questions to come in, Nikos. Oh, someone's raising their hand. Leonie. Go ahead. I think it's Leonie.
Yeah, that's correct. Yeah, so I'm from the Netherlands Human Rights Institute. So first of all, it's of course nice to hear that our letter actually worked. And it was very useful for us too to see how this implementation process works and engaging with the Rule 9 procedure. So thank you, Nicolas, and the rest for organizing this event and for helping us with the implementation of these European Court judgments. And I was wondering, because we are closely following up on the Corallo judgment, and so we engaged in this first part of getting the Committee of Ministers to look into the execution of this judgment through the enhanced procedure. And I was wondering, do we need to continue to follow up, like to the execution department? Should we provide new information? Because at this moment the situation is still the same. But should we provide letters saying, well, the situation hasn't changed as far as we know, or do we only follow up by providing new information when there is new information?
if I may, thank you for the question. This is a very useful, I think, issue for everybody. I would advise you to do two things. I mean, first of all, I think the advice would be to follow the situation as closely as possible and send us any new information that you may have. But at the same time, since you are an advisory also institution for the government itself, my advice would be also to consult with the government and see what they intend to do, because we have not heard actually anything on this particular case from what I remember since April 2019. From, I think the government replied, if I remember well, but do not have any new information either. So if you can consult with your government, see what they're doing, and then come back to us as soon as you can. Yes, that will be really helpful for us.
I think we've probably got time very quickly. If there's one other very quick question, if anyone wants to ask it, please go ahead. Otherwise, we'll start handing back over to Simona. Okay, I think we have a question from Tamar Abazadze. My question is somehow technical. I wonder, what is the difference between enhanced and standard supervision from a practical perspective? We know that enhanced supervision goes to leading judgments, but still. Nikos, maybe I can hand back to you for that.
Yes, that's a technicality actually, which did not exist before 2010. I used to work as a lawyer actually in the execution department in 2004 until 2007. And at that time, actually, there was no such distinction between standard and enhanced cases. All cases were examined depending on their stage of progress, actually. In 2010, there was a change of the rules of the Committee of Ministers, and they decided to establish this distinction between enhanced and standard cases, which means in practical terms, in enhanced, we have primarily all the cases which raise structural or complex problems. And this is something that is evaluated primarily by the execution department, and the proposal is made to the Committee of Ministers to decide upon. All the interstate cases also are always enhanced. And also all the pilot judgments are always enhanced. The rest of the cases are in standard cases. So one can say that theoretically the most important or the most difficult or the hardest cases are always going to the so-called enhanced procedure. But this should not actually lead one to the conclusion that they should not deal with the standard cases, because there are many standard cases. One of the side effects actually of the 2010 system is that many of the standard cases are forgotten actually, both by NGOs and national human institutions, but also by the Committee of Ministers. What we usually do in the execution department is that we send reminder letters whenever we don't receive actually an action plan in time or for a long time. We usually send reminder letters to the governments in order to provide us with new information. And this happens actually quite often in standard actually cases, because people think that these are not important judgments or important cases, but this is not true. This is something also that I would like to highlight, that every judgment has the same carries the same obligations for all respondent states. It has the same legal value under Article 46, and it has to be executed promptly, fully, and effectively, like the enhanced cases, the judgments in the enhanced procedure. This is something that we have to have in mind, and it will be very useful actually to be brought forward through this discussion today. Thank you.
Thank you so much, Nikos. In the chat, I've posted a link to the EIN guide to working on implementation of standard cases, and that provides a little bit more information, Tamar, on standard cases from our perspective, and fleshes out, echoes a lot of what Nikos said already. But I think that might provide some interesting information for you. It's interesting to think, just to carry on for what Nikos said, I mean, I think there's about 250 of the 1,250 leading cases are under enhanced supervision, and the rest must be sort of almost 1,000. I think these figures are about right, Nikos, are under standard. So there's a huge number of standard cases, and in fact, there's probably less government activity, a lot less government activity on standard cases in comparison to enhanced cases. So from our perspective, it's really valuable for NHRIs or NGOs to push forward implementation of those in any way that they can, because it's a bit of a kind of a slow area of cases, let's say. So it's really valuable to highlight those as you did. For now, though, I'd love to move on to our next presenter. Dr. Simona Drenik-Bavdek is Assistant Head of the Center for Human Rights at the Human Rights Ombudsman of the Republic of Slovenia. Now, I mentioned that one of the key ways that NHRIs can advance implementation of judgments is through promoting national mechanisms whose purpose it is to advance implementation. So the evidence shows that the existence of such mechanisms, when they operate well, is the most effective way to ensure ECtHR judgment implementation is pushed forward. Now, this applies to Slovenia. So if you look at the statistics, I think there's only 7 leading judgments pending at the moment, and 80% of the leading judgments from the last 10 years have been implemented there. So the evidence speaks for itself. Mechanism there seems to be working well. That's why we're really interested in having Dr. Bavdek speak. So I hand the floor over to her.
Dear George, thank you for the invitation. And I would like to say it is really a pleasure to me to speak at this webinar. As exactly almost 5 years ago, I was sitting in the office of the time Minister of Justice of the Republic of Slovenia, and we were discussing exactly the same issues we are discussing now, how to improve our record of the implementation of the Strasbourg court judgments. And we were developing at the time a system which at the time we thought might work, and after 5 years now we see it was successful, and it could be even a good practice example. So maybe first to answer on a question, why should the implementation matter to national human rights institutions? I think that the answer is very straightforward, and there are 2 arguments. The first one is a human rights argument, and the second one is the rule of law argument. On the human rights argument, already 1993 Paris principles relating to status of national institutions clearly establish a responsibility of national institutions to promote and assure the harmonization of national legislation, regulations, and practices with the international human rights instruments to which the state is a party under their effective implementation. European Convention on Human Rights is clearly such an international instrument. So, and we all know the obligations of states under Article 46. At the same time, the need to implement international obligations at the national level is also generally recognized as a rule of law standard. The second issue might be more challenging, and this is what are the key elements for the effective implementation of the European Court of Human Rights judgments in a country. I think there are 2 aspects, and a first one is a political will, while a second one, administrative capacity. On the political will, it is of course a conditio sine qua non for any implementation of judgments of international courts and tribunals, and the European Court of Human Rights is clearly not an exception. One might defer a general political will to respect human rights and the rule of law, or a more focused political determination to enforce judgments of the European Court of Human Rights. Political will might also relate to specific judgments, or is holistic, more general. Of course, political will is especially essential to ensure the execution of difficult cases, like in case of Slovenia, you will see later. Once a political will, however, is established by government and the parliament, it is then crucial that the state also possesses an administrative capacity. Even more so if we aim to promote a need for a holistic approach and integrity approach towards enforcement of all judgment of the European Court of Human Rights in a particular country. So this means proactive approach. What do we understand by that? This is understanding the required individual as well as general measures in each case, especially in leading cases, but in all cases, and in pilot judgments as well, especially. And then understanding Strasbourg enforcement procedure, which is very developed, to say that way. Then establishing an effective leadership and cooperation of relevant state authorities, organizing trainings for professionals, judges, state prosecutors, social workers, etc., etc., and preparation of, more technically, action plans and action reports. National human rights institutions can and should contribute to such developments within a state and should act as watchdogs. Well, for example, in Slovenia, Human Rights Ombudsman of the Republic of Slovenia has constantly promoting a need for the enforcement of the European Court of Human Rights judgments at various occasions for years, including through the action, the annual reports. Creating a supportive environment is extremely important. Like in Slovenia, neither a political will nor administrative capacity developed at once. In fact, I can say we faced a process of rather an evolution from an ad hoc to what I call a holistic approach, from a specific political will to implement specific single cases to a general approach establishing what we can now call a strong implementation structure. First, there was a political will to implement 3 judgments in 3 very publicly and politically exposed cases. These cases were a quasi-pilot judgment in a leading case Lucinda, joining 264 separate cases concerning lengthy court proceedings, and 2 pilot judgments in Kuric and Alešić case, which both concern specific situations following the dissolution of the former Yugoslavia, and had extremely high financial consequences, especially the Alešić case, as you may know. In all 3 mentioned cases, the government proposed to the parliament to adopt specific laws on the implementation of the judgment, and in order to properly enforce the judgment, also ensured significant financial resources. The laws were adopted in 2006, 2013, and 2015, respectively. Although the state paid more 100 million euros of compensations for these cases or just satisfaction and cost of the proceedings, there was still a number of unimplemented judgments by Slovenia. So in parallel, yes?
Sorry, Simona, sorry to jump in. I'd just love to ask you the question, can you tell us more about the structure of the Intergovernmental Working Group and how it was set up, but also explain who the members are and how it works?
Yes, of course. Well, we established, maybe just to mention, we established a working group, Intergovernmental Working Group. In 2015, there was a governmental decree which established actually 3 structures, or 2 structures, concerning the implementation of the European Court of Human Rights judgments. The first one was an intergovernmental working group for the coordination of the enforcement of the Strasbourg judgments under the leadership of the Ministry of Justice, and then a support unit which was established within the Ministry of Justice. And interestingly, the same decree also tasked the Ministry of Justice to amend the Human Rights Ombudsman law in order to ensure its compliance with the Paris principles. So in a way, the issue of having a strong national human rights institution was connected to a political will to implement judgments of the European Court of Human Rights, which is quite logical, I think, because in both cases, the same values of having a culture of respect of human rights prevails. So what are the members of the working group? It is chaired by the State Secretary of the Ministry of Justice. This means at the political level. And then the members are representatives of the Ministry of Justice and other relevant resources of State Attorney's Office, Human Rights Ombudsman, and of the Supreme Court. A group usually meets once or twice per year or as needed. And between the meetings, the coordination and expert work lies within a support project unit on the coordination of the enforcement, which operates within the Ministry of Justice. And this is, I think, very important that the unit has quite a lot of tasks and responsibilities, like initial legal analysis of each case regarding the needed individual and or general measures, a coordination of work and measures to be taken at different levels, including drafting or proposing legislative proposals, drafting action plan, action reports, and also a cooperation with the Council of Europe Department on the execution of judgments. I think this is also very important, to be actually engaged in the process and to really see what general measures need to be adopted. Within this structure, I think this is also important. Human Rights Ombudsman task is to monitor the implementation process and to give its opinions when necessary. We have two representatives in the working group. Both of them are deputy ombudsmen. In practice, a proper implementation of leading cases need constant monitoring. This is my view. For example, the government committed in an action report in a case Mandic and Jovic versus Slovenia to build a new prison in Ljubljana. And this commitment would need further attention, right, for example, by our institution. As you can see, the strategic approach allowed that not only the individual measures, but also general measures concerned could be successfully addressed. The results achieved so far are positive. Let me tell you that from 309 unimplemented judgments at the end of 2015, the number lowered to 49 at the end of 2016. Such a big change of the number was also due to closing a group case of Lukinda, which was joining 264 judgments. And then to 12 at the end of 2019. At present, according to my last information, Slovenia has 6 unimplemented final judgments out of a total of 345 final judgments. And I think 2 judgments are still not final, which also will be under the leading cases. It is maybe also worth to notice that since the establishment of a new administrative structure, despite the change of 3 governments in Slovenia, a positive attitude and trend towards a holistic and integrated approach to the execution of the Strasbourg judgments remained. And this is, I think, very positive to create a strong permanent structure and coordination with the proactive approach towards the implementation of the judgments. Because I think that if the judgments of the Strasbourg courts are not implemented, then the justice is only maybe halfway, because, well, even though, for example, the individual measures are implemented, but general measures, if they do not remain, they are not implemented, it would mean that basically same cases, same violations could happen over and over again. Maybe to conclude, I would like to emphasize two points. And my first point would be that we should be aware that there is no blueprint or a common recipe for all. One country might follow such an example as Slovenia of creating a strong national structure, but other countries might privilege other approaches. Some might be willing to make more use of Strasbourg advocacy, for example, to put pressures on their government. But I think what Slovenian example shows is that once a political will is joined with the necessary administrative capacity and good working levels among various ministries and other actors, a positive result can be achieved. And on the role of the national human rights institutions, I think our example confirms that there is a need for strong national human rights institutions in Europe. They need to act, we need to act as watchdogs in at least 3 levels of advocacy in this regard. I think first one, creating a strong culture of human rights, part of which is a need to enforce the judgments of the European Court of Human Rights and also not other international human rights obligations. A second one is calling for the enforcement of concrete final judgments, as well as for a holistic approach to implement judgments. And third one is calling for a proactive approach of the ministries of relevant actors and decision makers, including the parliament, to cope with the implementation issue and to ensure that the administrative capacity as well as proactive approach of the states exist or are ensured. I think in general, this is an example I wanted to share with you, and thank you for your attention.